Nope, and Attorney Matt Hauser here on behalf of Mr. Dan DeMoody.
Sir, can you state your name, please?
VJ Dan and Moody, Your Honor.
All right.
Chris Clare on behalf of probation. Your Honor, Mr. Dan DeMoody is before the court for a violation of probation hearing. The court, Mr. Dan DeMoody was recently before you, and this court had set the violation hearing out. I asked this court to set it for today. I did have a chance to speak with the victim in this case. The violations are still the same, Your Honor. It's a violation of the no contact order with the victim in this case, with the numerous emails that were sent, and the new criminal convictions with the both felony cases. This court was made aware at the last hearing of what that sentence agreement was for Mr. Dan DeMoody once he goes to court there. He already was sentenced on one of the cases to 6 months in jail, followed by 5 years of probation. On the other case, the conditions of that sentence or plea agreement to that is that he be released from custody on a GPS tether to inpatient mental health treatment, then on home confinement at his parents' house. Once that's completed, that's part of the felony case. Your Honor, I did have a chance to speak with Ms. Hodge and went over with her, so she clearly understood what took place with the felony plea and agreement. Given all circumstances, probation has amended the recommendation in this case. I don't normally do that when there's a clear conviction or violations. However, in the best interest of the victim and the defendant in circumstances that has happened to date, probation is now recommending that the court sentence Mr. Dan DeMoody to 152 days in jail with credit for 152 days served for his violations to date, that he continue probation in this matter with the added conditions: 1, to be released from custody on a GPS tether; 2, inpatient mental health treatment. Once inpatient mental health is completed, he's to be placed on home confinement at his parents' residence. That is in Battle Creek. And that should there be any outside necessary appointments, that Mr. Dan DeMoody remain within Calhoun, Kalamazoo, Berry, and Eaton counties. Also, that the court impose no use of internet for any reason except for documented medical appointments, with a scheduled review hearing being set April 20th, 2026 at 1 p.m.
Mr. Hauser, anything you have to say regarding that?
No, yes, that is an accurate representation of the conversations that have occurred over the course of the last week. I guess the only update I would have is just as it relates to the jail credit. Were we going to sentence less than what his current credit was? Because last week I believe it was 204. I'm just wondering where that 152 had come from.
Your Honor, I didn't count the prior jail time from the first violation. I just counted from his time in this time.
Yeah, okay, I see.
Does that make sense?
Yes, it does.
Okay.
It does. That because that's this sentence for this violation,
Correct.
right?
Okay. And then the only other item was, as was mentioned last week, there was the appointment at the Mayo Clinic coming up on the 26th. So there was that request for travel outside of the state. I believe the dates I received from Dr. Dan DeMoody, VJ's father, was February 14th through the 17th, and that would be travel from Michigan to Minnesota. Of course, all other conditions.
The courtroom reviewed a serious probation violation involving repeated contact with a protected victim and new felony convictions. Prosecutors outlined the breaches clearly, explaining that multiple emails and criminal behavior had violated direct court orders.
What apply?
And Your Honor, I would like it being clarified to the court and to probation about the inpatient mental health facility. The documentation that I show that this is taking place in Battle Creek. Is that right, Mr. Hauser?
Yes. Yep. It is. It is Pasadena Villa in Battle Creek. And I'm actually to follow up with Sabrina, the coordinator from there, after court today, based off of what is determined. And what I can do is I can also CC probation as well in any further communications with Sabrina, so that way all parties are on the same page.
So you're asking for permission for him to travel to Minnesota?
Yes, he has an appointment on February 16th at the Mayo Clinic in Minneapolis.
Okay, and when would he then return?
On the 17th of February.
On the 17th. So it's basically a 1 day.
Your Honor, the documentation that he sent to me, the flights would be leaving on February 14th and returning on February 17th.
Is that correct, counsel?
Yes, yep. The email I received from Dr. Danamuni was, yes, the flights would leave from Grand Rapids on February 14th in the afternoon, and then return the 17th in the morning. So it would be for a few days.
So the appointment on the 16th is documented. And basically the evening of the 14th, 15th is basically travel to that
Yes,
appointment. Okay, I'm not gonna have any problem with that.
Okay, Your Honor. So probation could notify community corrections of
Yes.
this being, okay.
That this is approved. All right. Anything else from the people at all? Or-
No, Your Honor.
All right. The court will sentence the defendant to 152 days in jail, credit 152 days served for his violations to date. The probation will continue with the added conditions that defendant to be released on a GPS tether to inpatient mental health treatment. Once inpatient mental health is completed, he's placed on home confinement at his parents' house at their residence in Battle Creek. Defendant to remain
Despite the violations, probation surprised the court by amending its recommendation. Instead of additional jail time, they proposed mental health treatment, GPS monitoring, and home confinement in an effort to protect both the victim and the defendant.
in the counties of Calhoun, Kalamazoo, Berry, and Eaton, with respect to any outside necessary appointments, with the exception of the Mayo Clinic in Minnesota that the court has just approved. There's to be no use of any internet except for documented medical visits. You understand that, Mr. Danbury?
Yes, sir, Your Honor.
All right. I'll set a review hearing in this matter April 20th, 2026, 1 p.m.
Thank you, Your Honor.
Thank you. Let's call the case of the people versus Roberto Evans.
And Zend on behalf of the people.
Ron Brown appearing on behalf of Mr. Evans. He's in custody, Your Honor.
Oh, we have to wait.
Oh, he's on Zoom?
Do I have an out of custody?
No.
No, I don't, because it's not. Okay.
Stay right here.
Hey, Your Honor,
Well,
You want to state your name?
Roberto Evans.
all right. What are we doing?
We're here for a pretrial, Your Honor. I also received this morning a domestic violence bond violation report.
From Pittsfield?
Yes, Your Honor, dated January 30th.
Yes.
Your Honor, I've shared it with my client. He understands he has a right to a hearing. He's willing to admit that he violated condition number 9 in that he had contact with Curita Bryant, Your Honor. He went over there to obtain his mail. He pays the bills over there. So he went over there to get his mail to pay his bills. She's on the lease and he's on the lease.
Yeah, but he understands he's not supposed to be there.
Yes.
And then that makes no sense to go over there and get your mail without,
Well, he's got to pay the bills.
well, he could have arranged for a civil standby to go get his mail if that's what he wanted to do.
I know that now. That's what I would do for.
No, you knew it before because it was given as a condition of your bond.
And Your Honor, I also have concerns that he moved a .323 VAC when he was picked up for the stop violation as well.
What was it?
.323.
Yes, Your Honor.
All right, so what are we doing on this case?
Your Honor, I'm requesting an adjournment.
I'll adjourn the matter to
March 2nd.
You don't have
March,
any dates for in custody sooner?
that's our next, March 2nd, 2026. 9 AM. Part of this, but the bond violation in and of itself didn't reference the alcohol use,
Nope,
I don't think.
no. I didn't see it.
Your Honor, on the
Well, it does, I see.
Well, it does and it doesn't.
What do you mean?
I mean, on the second page, it says, no use of alcohol, no contact with Quit Bryant, do not go to 2152 Glencoe Hills. And the officer had reasonable cause that the defendant violated those conditions. So I didn't have the amount of alcohol that was in his body. I just had in the cover sheet, complaint of violation, conditional release signed by the investigating officer, says no use of alcohol, didn't have the amount for the level.
We now know it's a 323. So
Your Honor, he's employed. He just got a raise and he was promoted to manager across the street at the Kentucky Fried Chicken on Washington.
yeah, but the problem is he can't go. There's a lot of alcohol. That's number one. And then he's going there in violation of his bond conditions. I'm not sure how we keep him.
Your Honor, he has an alternate address where he can reside with his sister. And if the court were to put him on a tether,
But a tether doesn't help us.
GPS would.
The judge imposed strict conditions, including no internet use for any reason except verified medical appointments. Travel was limited to specific counties, with one carefully approved exception for a Mayo Clinic appointment.
Well, it really doesn't help us because he went someplace he wasn't supposed to go, regardless of what his reasons are. He wasn't supposed to go there. And he had a mechanism by which he could have gone there to get his mail. He chose not to do that. And then chose to just drink a boatload of alcohol. I guess that's not a quantifiable amount, but
May I say something, Your Honor? I didn't.
at your own peril, go ahead.
I did not go inside the place. I did go there, but I did not go inside the place. And I was outside of the place. I knew I couldn't go in, and I didn't. And even when the officers showed up, I was not even at the place. I wasn't even nowhere near the place. I went there for a reason and I left.
I think the report indicates also that the complaining witness did not know that he wasn't supposed to be there.
Whether she knew, he knows.
I've explained that to him, but bills were due, Your Honor. It's the end of the month.
And kids to stay there, and I had to just make sure everything was intact because we got
He
6
could have done all of that with a civil standby. That was explained at his arraignment. He could have done everything that he had a concern about with a civil standby. But instead, what he's chosen to do is to go out there and drink and then just go over there and then try to split hairs with me. Well, I didn't go inside and I thought I could be there. He knows he can't be there.
He's dealing with the practicality of having to pay bills. That's all, Your Honor. The lights, the heat, the rent.
Send cash. I don't know what you want me to tell you to do. The problem is he can't be there.
I will not go back there, Your Honor.
At this point, his bond will continue as revoked. We'll see him on the second.
Thank you.
That gentleman was raising his hand about right there. Court calls the case People versus Kent Robinson.
Alexander on behalf of people.
Rod appearing on behalf of Kent Robinson. Introduce yourself.
Robinson. Thank you.
I'm requesting a 2-week adjournment if possible. He's in custody. He has a PCC on Thursday.
This Thursday.
Yes, Your Honor.
Well, my next available date's the second, so that's about where we are. It's a little bit longer than that, but
Your Honor,
yes.
if you take any action on his bond, reducing it on Thursday, may we join in that motion? On this case, I think he has a nominal bond in this case.
He's what?
He has a nominal bond in this case so that he's garnering credit while he awaits disposition of the felony.
Right, he's got $100 bond basically on this case.
Yes, Your Honor.
And on the felony, if I were to reduce it, certainly I would take a look, but I don't know. I don't have that in front of me.
Just
Go.
for the court's reference, on at least the felony I have on extra that his bond is denied, because I believe he picked this up while on.
Got it. So that's probably unlikely to occur.
I gotta ask, he asked me to ask today.
Adjourn this matter to March 2nd.
With credit for time already served, the defendant was released under intense supervision and scheduled for a future review hearing. One mistake had reshaped his freedom, and the court made it clear there would be no more chances.
2026,
That's the earliest.
1 p.m.
Got $100 bond on this case. We'll see you
It's
Thursday.
1 week out from what you requested.
Thursday.
Thank you.
Thank you. Is that it? All right. What?
Till 1 o'clock.
Till 1 o'clock. All right. I'm actually ahead. I'm impressed by me. 14A stands in recess.